Ms. Mushasedi.
Good morning, Chair.
Good morning to you too. Good morning, Mr. Nciza.
Good morning.
Thank you.
Good morning, Mr. Nciza.
Morning, ma'am.
Yesterday, we closed off with a discussion of Annexure PN2. Actually, before we go there, Mr. Nciza, please confirm that you still have both files, the witness statement and the annexure bundle in front of you.
Yes, I do.
Thank you. If we could then pick up with your witness statement. We were on page 11, paragraph 27. Page 11, paragraph 27. Please let me know when you're there.
I'm there.
When we closed off yesterday, we had worked through annexure PN2, which is in your annexure bundle. It contained screenshots of a discussion between you and your superior, Mrs. Bashega.
Yes, ma'am.
Thank you. I don't need us to work through that again, but we can perhaps just provide a recap of where we closed. In summary, the WhatsApp conversations reflect the discussion you had with Ms. Bashega on the 20th of February 2023. Is that correct?
Yes, it does.
Thank you. Wherein she raised with you a need for security in light of the disciplinary action that you intended to take, at least the suspension that you intended to take with respect to the brigadier. Is that correct?
Yes, it was in respect of the suspension.
Thank you. If you...
Sorry. May I just ask this? Morning, Mr. Nciza.
Morning.
I had meant to ask yesterday, and it's because of what happens later, and in particular, the circumstances in which Mr. Mkwana's suspension was uplifted, and then he was told to come back. So it is in that context that I asked the question. Where you say that Ms. Bashega expressed that, and if I don't want this thing, do something about it. You remember that evidence?
Yes.
Did you understand her to be reluctant or not to want to be part of the suspension decision and process? What did you understand of that?
Thank you, Madam Commissioner. Indeed, my understanding was that she was reluctant because of the risk associated with the suspension itself. I didn't understand her to be reluctant in respect of the substance of the issues that pertained to the suspension, but it was the risk issue that she expressed more concern about. She did not express concern about the allegations themselves.
Thank you.
Thank you, Commissioner.
Can I just follow up on that? On page 12 in the bundle, PN2.
Yes, Commissioner.
Are you there? PN2, page 12.
Yes, I am.
You say there we need to strategize around it. Our subordinates have horror stories.
That's not me.
Is it not you? That's her.
That's Bashega, yes.
Okay. And did you know what she was referring to? Because, I mean, at this stage, all you are dealing with is the suspension of a brigadier. Why would there be concern about safety of yourself or Bashega or other people at that stage? Forget about what happens later on.
The concern about safety, if you read the commencement of the WhatsApp engagement, I had expressed a view that this matter is not going to be a simple disciplinary matter, because it involves a character who's outside of the institution, who is in the news, and is in the news for wrong reasons. So she also responded to say that indeed this is a very delicate issue, you know. Now, on page 12, you would see that she had firstly requested or rather asked whether indeed there was a risk assessment conducted as per the WhatsApp on page 11 at 11:03. So the risk assessment was a key issue to her. But then she expresses another concern at 11:07 on page 12, where she says, but I don't want people penetrating my private space. Nah. I'm too private for Lama VIP who reports issues to some of our subordinates. So what she's talking about here, in the institution, under the Specialized Services Unit of EMPD, we've got the VIP Protection Unit that then would have guards or they call them inspectors. So everybody that is a VIP Protection Unit member is an inspector. Those inspectors are then allocated principals. Now, what Ms. Kashega was raising is to say these people have tendencies of relating the private life of their principals, you know. So she says to me that I'm a private person. I don't want to be guarded by these people because my issues will be known, you know, in the institution. And that is what she's trying to deal with. And hence, her response to my 1109 message that talks about strategies is informed by that concern that she has, you know, with regards to intrusion of her private life. Yeah.
Thank you, Commissioner. Thank you, Commissioner. Mr. Nciza, let's just make two important points here. If I could ask you to turn to page 9 of that exchange, page 9. You send a message at 11:03, the nub of which is you confirming that despite the security challenges, you are going to send her the pre-suspension letter within the next 15 minutes. Is that right?
Yes.
Thank you. If you then just turn over the page to page 10.
Yes,
At 11:04, Ms. Kashega asks you, have they done EMPD preliminary investigation though? And you respond immediately, yep.
Yeah.
Correct. So you respond in the affirmative to say that EMPD has at that stage where you are on the brink of issuing the pre-suspension letter, a preliminary investigation has been done.
Yes, I responded in that manner, Counsel, because you recall that I had indicated in my testimony yesterday that I had a session with Commissioner Spies and Lieutenant Colonel Erasmus, where indeed they had indicated to me the assessment that they had conducted, what I called some form of a desktop analysis of the registrations and the likes. So when she asked me that, my response was in respect of the discussion that I had with Spies and Erasmus.
Thank you. Could I then ask you to stay in the annexure bundle and just flip over the page to annexure PN3. PN3. The actual document itself will begin on page 13 of your annexure bundle.
Yes, ma'am.
Okay. Just to locate us in your witness statement, you are now at paragraph 28. And the annexure we are looking at now is PN3 that starts on page 13.
Yes.
Thank you.
There.
Could you just confirm for the commission what is the title of that document at the top of the page in bold?
The document is titled Intention to Suspend to Suspension Letter.
So please confirm that that is the letter you were referring to in your WhatsApp communication with Ms. Kashega as
Yes, it
discussed. Thank you. Right. At the top left corner of the page is a date. Do you confirm that that's the 20th of February, 2023?
It is the 20th of February, 2023.
Thank you. If we have regard to the box, the details in the box just under the heading of intention to suspension letter. The suspension letter relates to which employee
Mr. Julius Mkhwanazi,
who at that time occupied what designation?
Director Specialized Services / Brigadier.
Thank you. Sorry. If we'll just go through some key aspects of this letter, it reads, Sir, the municipality has received allegations of serious misconduct against yourself. The allegations that have been received by the municipality relate to the following issues, and it lists 6 issues under there.
Yes, ma'am.
Ms. The third paragraph then, the paragraph beginning, the employer has reasonable cause to believe.
Yes.
Are you there? Thank you. Could you set out briefly for the Commission what are the reasons that motivated the issue of this intention to suspend letter?
The suspension letter started off, of course, by enumerating the issues in terms of the allegations that existed at the time against Brigadier Mkhwanazi. Then the employer would this is the standard that we took from the collective agreement, that if you're going to suspend an employee, you must articulate that your suspension is in relation to these factors as per the collective agreement. So the factors that would inform the suspension would be 1, that his presence you may jeopardize the investigations that are required to be conducted on the matters raised above or herein. 2, you may interfere with potential witnesses. 3, you may commit further acts of misconduct. Yes.
Thank you. And the paragraph right beneath.
Mr. Nciza, what informed number 3?
Mr. Chair, that our experience is that indeed when an employee who is facing allegations of misconduct, especially allegations of misconduct of this nature, the nature of these allegations was such that they might be continuous in their very, in the conduct of the employee. The registration of the vehicles, yes, had been done, but the fact that the registration continued, he might do certain things, and indeed he did do certain things that I will talk to further on, to misconduct himself further. It might happen. There are issues about dishonesty. And if indeed an employee interferes with documentation, that is a perpetuation of the dishonesty. So that's why we always have this to say, is there a potential for this employee to commit further acts of misconduct, which might be linked to the allegations themselves, or even his presence in the workplace might actually expose the institution to further acts of misconduct?
Thank you.
Thank you, Chairperson. Mr. Nciza, the final paragraph at the foot of that page invites the relevant employee to provide representations on why he or she should not be placed on precautionary suspension. Do you see that?
Yes, ma'am.
Indeed. And it invites them to provide those representations by the 22nd of February.
Yes.
Okay. Can I ask you then to flip over the page?
Yes, ma'am.
Right. Paragraph 5 at the top of the page requires the relevant employee to vacate the premises of the employer with immediate effect. Do you see that?
Yes, ma'am.
Thank you. Could I then ask you to identify the first signature that appears under yours faithfully?
The first signature, Commissioners, is my signature, Xolani Nciza, DH Employee Relations.
Followed by the signature beneath, please, belonging to?
The second signature belongs to Linda Glashega, who at that time was the acting HOD HR.
And then please identify the final signature, the third from the top on page 14.
The final signature on the document is an acknowledgement of receipt signature. The person had printed his name, J.D. Mkhwanazi, and had signed and also dated the document.
Please provide the date.
The date is the 21st of February 2023.
Thank you.
Are you reading the letter? Yes. Okay. Maybe then let me ask my question. In the first page at 13, page 13, you've got Roman figure 3 and 4, and the allegation of gross dishonesty and possible corruption by receiving a donation in excess of the limits prescribed by council. And then the second one says allegations of violating council policy by not declaring the donation. Now, the evidence so far that we have had that relates to a donation is about printing material of about 300,000 rand by CAT VIP. Is that what this refers to, or it's a different, in your recollection? I realize it was in February 2023 when you signed this. If you can recall, was this something different to this printing material for cadets in the amount of about 300,000?
The allegation that was brought to our attention was framed in these terms, Madam Commissioner. Remember, at this point, we as the Labour Relations or Employee Relations Unit and HR per se were not seized with the actual investigation report that would have then detailed what exactly the donations were about. But on this day, when we crafted this letter, it was on the basis of the submission from the department to say that was a donation, but the nature and form of the donation was not clarified at that particular point.
And then secondly, in page 14, where you say he's required to vacate the premises, that very last paragraph there, the paragraph doesn't say to him, which we have had happened to Chief Mapiyeye and to Commissioner Spies. It doesn't say to him he must surrender his tools of trade, his firearm, and his computer. Does that mean he was allowed to keep this when the other two were told to hand in even their firearms? What does this mean?
Perhaps, Madam Commissioner, I can start off by indicating that what happened with Chief Mapiyeye and Commissioner Spies was not the standard process. You know, this is a pre-suspension letter. It's not a suspension letter. The person is not suspended. You know, this is a letter that says there is a view that the employer has taken that we should suspend you. However, we must give you an opportunity to present, make representations why you should not be suspended. So at this point, you're not suspended. So there's no basis for me to say hand over things when you're not suspended. You know, and we use this paragraph on page 14. You know, we remove you indeed from the premises so that you go and actually concentrate on crafting your representations, but also to ensure that there is no malfeasance that happens in the process. Because the minute a person receives this, and again, it's experience, you know, we give an employee this, and then you hear from witnesses or from other colleagues to say that, hey, you know what, this person was doing this person was at the office looking for files and all sorts of things. So we prefer that you move away, but taking tools of trade is premature. You know, hence, I would not put that in a pre-suspension letter because you are not suspended. The minute I take tools of trade, I have effectively now prejudged, you know, the representations that have not yet been made. It has happened in instances where a person makes representations and then it convinces us that there is no basis to suspend. You know, we can still continue the investigations whilst the person is at work.
And was the procedure that all suspensions must be preceded by a pre-suspension notification such as this, inviting them to make representations? Was that how it works? It's
like that. It's clause 16 of the collective agreement. Even on the disciplinary regulations for senior managers, clause 5 of the clause 6 of the regulations speaks to that. There must be an opportunity provided to the employee to make representations.
And senior managers in this case would include even chief of police and his deputies.
The chief of police, like I indicated yesterday, you have three categories. Senior managers would be the chief of police, HODs, and the city manager, as per the Municipal Systems Act. And then your divisional heads, like Spies, who was on the same level as I was, would then be the category that is the middle strata. And then everybody else falls under the bargaining unit of the bargaining council, and therefore they are regulated by the collective agreement.
And you confirm that that pre-suspension process did not happen with Chief Mapiyeye and Commissioner Spies?
I was not involved, Madam Commissioner. I know about the processes, and I've listened a bit to the testimony that both gave. The process that happened is exactly as stated in the collective agreement. I mean, in the regulations for chief of police, provide an opportunity for representations to be made. You know, and my understanding is that that did happen.
Okay.
But what I find fault with what happened is the issue of then taking tools of trade before a determination is made.
Okay. Well, we've heard from Commissioner Spies yesterday that he had attended an arbitration as a witness for the employer, and then it is at that he was told you are on suspension. So it sounds like with him, at least, I don't remember Commissioner Chief Mapiyeye's evidence on this issue, and we'll accept you saying it happened there. But Commissioner Spies seems to have had a completely different experience. Do you have any personal knowledge of that?
Like I say, by the time all of this was happening, I was no longer in the institution.
Okay. No, I remember
but
that.
if it happened that way, it was wrong.
Okay. Thank you. Thank you, Ms.
Thank you, Commissioner. Mr. Nciza, we've then wrapped up with respect to Annexure PN3. Could I ask you to stay in the Annexure bundle and then proceed to the next Annexure PN4, which begins on page 15? Are you there, please?
I'm there.
Thank you.
There, ma'am.
And for context, we're now in paragraph 29 of your witness statement on page 11. Again, my apologies. Please identify the title of the document on page 15.
The title of the document is Suspension Letter.
Thank you. And the date reflected there, Mr. Nciza, according to your witness statement, there's a slight correction you would like to make?
Yes. That this is a suspension letter that I drafted on the 24th of February. Unfortunately, it's reflecting 20th February on the letter itself, but it was actually on the 24th of February. And you can also discern that from even the contents of the letter. The letter could not have been drafted on the 20th because the letter refers to an event or process that had occurred on the 22nd.
Okay. I'll take you to that specific part of the letter now, but can you confirm that the suspension letter relates to Mr. Julius Mkhwanazi?
Yes, it does.
Thank you. Mr. Nciza, the first paragraph of the letter, could I invite you to read that first paragraph, please? Beginning the notice of?
The notice of intention to suspend you issued by the municipality on the 21st of February 2023, as well as your written representations dated the 22nd February 2023.
So we can glean from that first paragraph that Mr. Mkhwanazi made written representations in response to the pre-suspension letter on the 22nd of February 2023.
Yes, he did.
And therefore the date of the suspension letter therefore could not be the 20th of February 2023. Is that correct?
It most definitely could not.
Thank you. In paragraph 2, the letter then responds, or the letter then says, the notice served upon yourself called for submissions of written representations in respect of a determination of whether to suspend you or not. Do you see that?
Yes.
Thank you. please read the contents of the third paragraph?
The third paragraph,
Yes,
the
please.
submissions.
Indeed, yes.
The submissions received from yourself do not in any shape or form provide reasons why the employer should not place you on suspension.
And you then cite the authority for that in the next paragraph? Is that correct?
Yes.
My apologies. And in paragraph 5 provides that the employer hereby suspends you from work pending the investigation and conclusion of any possible disciplinary proceedings that may ensue in terms of the provisions of the disciplinary procedure collective agreement. Is that correct?
Yes.
Thank you. And you then set out the reasons there warranting the suspension.
Yes, ma'am.
Thank you. Paragraph 6 then at the foot of the page sets out the conditions that apply in respect of the suspension.
Yes, ma'am.
Can I ask you to flip the page then to page 16,
Yes, ma'am.
where I'll ask you to again identify the respective signatures on that page.
The signatures that are on page 16, commissioners, are myself, Xolani Nciza, DH Employee Relations, Ms. Linda Tasheka, Acting HOD, Human Resources, and acknowledgement of receipt by J.D. Mkhwanazi with his signature and the date that he had received, which is the 24th of February, 2023.
Ms. Nciza, if I may confirm then, the date of signature of the suspension letter would then be the 24th, correct?
Yes.
Right. And the subject matter of the investigations at this stage is based on a preliminary investigation at this point. Is that correct?
Sorry, ma'am.
The allegations under consideration at this point are based on the preliminary. Yes, the
Yes.
allegations that make up the subject matter of the suspension at this point are based on the preliminary investigations that have been reported to you at this point.
Yes.
Thank you. All right. Could I then ask you to turn to page 12 of your witness statement? Could we go back to that file? Page 12 of the witness statement, and you are in paragraph 30.
Yes,
Indeed.
I am.
Thank you. And in paragraph 30, you indicate that Brigadier Mkhwanazi was suspended for 3 months in terms of clause 16 of the DPCA, that's the collective agreement referred to in the suspension letter, which suspends him from work pending the investigation and conclusion of any disciplinary proceedings. Is that right?
Yes, it was.
Indeed. So if his suspension date was effective from the 24th of February, the suspension would then be effective for the next 3 months up to May, correct?
Yeah, 24th May.
Thank you. Please then take the commission through the subsequent developments after the issue of the suspension letter. You are now at paragraph 31 of your witness statements.
31.
31 on page 12.
So, just for clarity, I need to take the commission, the subsequent developments on this matter of Mkhwanazi.
Indeed, following the issue of the suspension letter.
Commissioners, as I proceeded to, of course, deal with my other duties in the institution, which was involving all departments in the institution. But there is an acknowledgement that I've always had that EMPD had the highest number of disputes in the institution, disciplinary matters, I think, because of the nature of the work that is performed by Metro Police officials. You know, they are working with the members of the public, so you would have all sorts of allegations that get raised, whether it's issues of assault, it's issues of bribery, it's issues, that concern the conduct and behavior of the metropolis officials. So I would then regularly engage with the department on matters that impact discipline in the department. So we had a number of briefings that ensued in respect of especially the investigations in Brigadier Mkwanazi's unit, the investigations into the blue lights scandal, but they also raised issues with me regarding other investigations that were underway, inclusive of investigations against Mackenzie, Stalls, and Twala, who were constables working in the specialized unit section. Now, during those briefings that I would receive, I would say that I received what I can only term and describe as horror stories, about what was happening within the unit, and I was kept abreast of even engagements that the chief of police was having with IPID regarding these officials, Mkwanazi, Mackenzie, Stalls, and Twala. So, yeah, I received a lot of information about the cases that were dealt with, issues of copper theft, issues of even murder, extortion. There's a number of issues that they briefed me about regarding these individuals.
The information you received relating to these three other officers was just as serious as the information relating to Brigadier Mkwanazi. Do you know why they were not suspended or even issued with a letter that requires them to make representations regarding why they should not be suspended?
My recollection, Commissioner, is that indeed they were suspended. There's a point where we suspended them. There's a point where I recall that I even instituted disciplinary proceedings against them. I did institute disciplinary proceedings. I appointed the disciplinary tribunal committee, and the process was to commence. And I later learned that indeed there were problems with regards to the processing of their case. At some point they were arrested, so the action was taken against these three. It's just that it was not taken forward, but my office had instituted proceedings against them. But I understood later on that there was a problem with the presiding officer because he was not paid by the municipality for other matters that he had done for the municipality. So he had served some notice to the attorney to say that he is not going to be able to proceed if he does not get paid for his services that he had rendered to the municipality. That is the big problem, of course, the payment of attorneys for services rendered. But action was taken against these three.
Thank you, Commissioner.
If I may, according to the evidence, so far, the conduct or the misconduct of these three officers came to light because of IPID's report once there was engagement with IPID. Now, internally in the municipality, at least up to the time that you were there, was there a process or a mechanism where employees can report concerns about the conduct of people such as this, the conduct that subsequently came to light through IPID? Was there a mechanism for employees to do that and to do that in a safe way?
The municipality, Madam Commissioner, has a whistleblower policy. I'm the first to admit that it had not been used or utilized utilized by the municipality to its fullest. But the municipality has the whistleblower policy. It's even on the intranet of the municipality. There were campaigns at some point by our communications department to promote, accessibility to whistleblower processes. And we've had a number of instances in the municipality where we've had whistleblowers. We investigated the issues that were raised by whistleblowers, and indeed, action had been taken against officials on the basis of whistleblower processes. Now, on these specific ones, you are correct that indeed we came to know about their activities as I was briefed through IPID, But what happens is when we've got matters that concern Metro Police officers, you would have two types of investigations. You would have the internal affairs investigation or integrity and standards, and you'll also have an IPID investigation. Now, if you have an IPID investigation, the department would then do a cover letter in that form that says we've got this investigation with its annexures, therefore bring it to me, but I would need something from the department because the department has to take ownership. Even if it's an IPID investigation, the department must take ownership. So then the chief of police will then bring to me a request for a disciplinary tribunal. And in that request, they would indicate that here is an IPID report that has a negative recommendation against this officer. So therefore, as labor relations or employee relations, you need to take this forward. There would be that request to initiate disciplinary proceedings against that particular employee. So if my recollection serves me well, that is what would have happened here. They would have provided me with an investigation report, and then I instituted the disciplinary tribunal.
Thank you, Commissioner. Just to close off this aspect of your evidence, Mr. Nciza, at the end of paragraph 34, the last sentence then, you confirm that you were informed that in addition to investigating these criminal offenses, the ones discussed above, IPID was also investigating the role of Brigadier Mkhwanazi in the Blue Lights scandal. Is that correct?
Yes, it was.
Yes. And that in the paragraph above 33, you were informed that even though your discussion related primarily to the issue concerning the blue lights, the IPID discussions had revealed that there was a broader problem involving further police officials, and that was brought to your attention.
Yes, it was.
Thank you. Mr. Nciza, we are then beginning a new subheading entitled Disciplinary Tribunal. This is paragraph 35 of your statement. We're still on page 13. Once you are at paragraph 35.
I'm there.
Thank you. Could you please describe to the Commission the developments of that day? Paragraph 35.
Thank you, Council. On the 12th of April 2023, Chief Mapiyeye, Commissioner Spies and Lieutenant Colonel Erasmus came to my office and they presented to me what they term a docket that contained the investigation report onto the allegations that were leveled against Brigadier Mkhwanazi. We went through the report, and of course, I engaged them on the content to say, but, we're talking about this letter of October 2021, what are the issues? And then I approved that a disciplinary tribunal be constituted, because they in my view, their investigation report ticked the relevant boxes that would convince an HR practitioner that there is a basis for this employee to answer to these allegations that have been leveled. So indeed, after we had consulted, I appended my signature to the disciplinary tribunal initiation form, And then we also then discussed how to handle the process. You know, they raised issues with me to say, as much as they had briefed me on several occasions around the matters that concern Mkhwanazi, Mackenzie, Stolz, and Twala. And there was also some process that had started with regards to the other three. They indicated that IPID was confident and convinced that there were imminent arrests that would be made, which would include Brigadier Mkhwanazi. So they requested that instead of proceeding, as much as I've approved the Disciplinary Tribunal, but I must provide them and provide IPID with an opportunity to conduct these other processes. And then we will then assess the situation. If indeed there are arrests that are made, then it might not be prudent for me to institute an appointed Disciplinary Tribunal. You know, because there are timelines. The minute you've appointed a Disciplinary Tribunal, there are timelines that must comply with in respect of the collective agreement. So we need to play this in a manner that we're able to ensure that we don't incur even some fruitless expenditure, because you appoint a disciplinary tribunal for a matter like this, and then people start working, and then the person gets arrested. You can't even proceed with the disciplinary inquiry and still be expected to pay for the services that you would have sort of incurred from attorneys and the likes. So that was the discussion on the day. And lastly, in the discussion, we decided that they must actually keep the docket because of the contents thereof, and I didn't want it to lie around in my office. I just needed it to be kept in a safe arrangement.
Thank you, Mr. Nciza. Commissioners, before we proceed on this issue, I'm going to request that these documents are handed up to you by our attorney, please. They somehow seem to have not made it to the annexure file, but we'll attend to sorting that out over tea. Thank you. Yeah, so each of them will get like that. Perfect. Thank you, Commissioners. The documents presented to you are numbered 15A and 15B, and we'll paginate them properly and insert them at the right place in your files. For now, we're going to make reference to them in this course of Mr. Nciza's evidence. Mr. Nciza, could you confirm that you are in possession of the two documents handed up to the commissioners? 15A is titled Directive for Implementation of the New DPCA. Do you have that document?
Dated the 15th of February, 2018.
Thank you.
Yes, I have it.
Thank you. And then the second document is a document from the South African Local Government Bargaining Council, Circular number 1 of 2008. Do you have that document?
2018.
8th of February 2018?
Yeah,
Thank
I
you.
have it.
Thank you. Thank you, Commissioners. Okay. Mr. Nciza, could we then turn to, if we could take a few steps back and return to paragraph 36 of your witness statement, where you say, I concluded that there was indeed a case warranting that a disciplinary tribunal be constituted. Do you see? Can you confirm that?
Yes.
Thank you. If I could ask you to have regard to circular number 1 of 2018, that's the DPCA itself.
Yes, I have it.
Thank you. you'll see that there's an index describing the issues that are regulated by this document. Are you there? Thank you. We're going to focus specifically on clause 7, which relates to disciplinary procedures, in this case, as they regulate a municipality. But I would ask you to please turn to clause 4, which is on page 4 of that document.
I'm there.
Thank you. So clause 4 would regulate the period of operation, right? So the DPCA, as it applies, sets out the period in which it operates. Could you just record for the record what that period is?
On clause 4.1 of the agreement, the period of operation is from the 1st of February 2018, and it will remain in force and effect until the 31st of January 2023.
Thank you. Are you able to confirm to the Commission its status here today? So does it still apply?
Yes, it does, because after the date of 31st January 2023, it then says, thereafter, the agreement shall continue indefinitely in respect of the parties to the agreement.
Thank you. And for completion in respect of this document, the DPCA is the same document that you reference in your witness statement as providing for the suspension. In particular, you cite the letter of suspension cited clause 16. Is that correct?
Yes, it is.
Yes. So the document regulates several processes from a bargaining council level, and we will consider specifically the issue of disciplinary procedures. Is that right?
Yeah.
Okay. Mr. Nciza, I'm then going to ask you to turn in the same document to clause 7, which begins on page 5, clause 7.
Yes.
Okay.
I'm there.
And clause 7 is entitled disciplinary procedure. Could you read into the record the contents of clause 7.1, please?
An allegation of misconduct against an employee shall be brought before the municipal manager or his authorized representative for consideration and decision.
Thank you. And who is an authorized representative in this context, in the Ekurhuleni context, as an example?
Like I said yesterday, commissioners, how we apply this collective agreement in the municipality, we have sort of categorized it. You know, you would have an authorized representative, as envisaged in clause 7.1, would be the head of department. But an authorized representative, as you go on with the collective agreement, would change. You know, it's not a one person. It's not one person. In other municipalities, you might find that it's the municipal manager or this particular person will be responsible for all the issues that concern a collective agreement. But in our city, we didn't do it like that. We sort of decentralized the processes in terms of our delegations matrix. So in terms of 7.1, it will be the head of department as an authorized representative.
Thank you. See, paragraph 7.2 reflects a principle then that disciplinary proceedings are to proceed promptly without undue delay. Is that correct?
Yes.
Indeed. Then paragraph 7.3 provides that if the municipal manager or his authorized representative is satisfied that there is a prima facie cause to believe that an act of misconduct has been committed, he may institute disciplinary proceedings against the employee concerned. Is that
Yes.
correct? Okay. Could you just briefly explain how that applies in practical terms to the Commission?
In practical terms, this would be, you have an allegation of misconduct that has been received in the department. The department then, in terms of the consideration of the allegation, the department would then institute an investigation. And having instituted the investigation, having then received the outcome of the investigation would show that there is indeed a prima facie basis for you or prima facie cause for institution of a disciplinary process. So then the department would submit to my office. Once they've got that prima facie cause, then they would submit. They would not themselves institute the disciplinary process.
Could I ask you to turn to the next page? Clause 7.4, which provides that the disciplinary hearing shall commence as soon as reasonably possible, but no later than 3 months from the date of the municipal manager or his authorized representative's decision to institute disciplinary proceedings.
Yes.
Thank you.
So once indeed the investigation has been concluded and the submission is made in terms of the initiation of a disciplinary process, the authorized representative has got 3 months within which to constitute the disciplinary proceeding.
Thank you.
The disciplinary tribunal.
The next 2 paragraphs then posit 2 options that are available in the event of misconduct. Paragraph 7.5 regulates misconduct that appears to be less serious. Is that correct?
Yes.
Indeed. And then paragraph 7.6 regulates misconduct that appears to be sufficiently serious.
Yes.
Indeed. And what is the course or avenue to be followed according to clause 7.5, where the act of misconduct is one that appears to be less serious?
Where indeed the act of misconduct is less serious, like I had explained, this is an instance where a probable sanction would be a written warning. Therefore, would either have a counseling session or else just issue a written warning to the employee. That is handled as a departmental inquiry, is handled internally by the department. It does not really require that I establish a disciplinary committee. So that can be handled by the department at a departmental inquiry level.
And where the act of misconduct is one that is more serious, what is the route that is then followed?
The route that is then followed is that the department, having submitted the investigation report, and if indeed, having applied my mind, I consider that indeed this matter requires a disciplinary tribunal, I would then authorize that a disciplinary tribunal be constituted, and having authorized that it be constituted, I then have to move forward to implement the appointment processes for the disciplinary committee.
And those processes are set out in clause 7.6.1. Do you see that, Mr. Nciza?
Yes.
Thank you. And could you just briefly explain the contents there of who is to be appointed and the alternative appointment that is available in the event that a disciplinary tribunal is authorized?
Thank you, Council. You would find, commissioners, that 7.6 and even 7.7, how it's structured is it has a default position. The default position in the constitution of the disciplinary committee is that in the first instance, you shall appoint a person internally, and in respect of this, what we did as an institution in my tenure as the divisional head, we had a panel of people that were trained as presiding officers as well as employer representatives. So if we get a request from a department to constitute a disciplinary tribunal, we would look at firstly the merits of the matter, what type of case is it, what is involved, the level of the employee and the likes. And then we would then look at our panel. Are we able to find a suitably qualified person in our panel to deal with this matter? Now,
And you are still talking the default position there.
yes, that's the default position.
So the panel would be people within
The default position.
municipality.
The municipality. Our panel is people that we've trained in the municipality. And I need to admit that as much as we had done much in terms of in building the necessary capacity internally, you would find that your senior people from divisional head and HOD level, really do not have time. They simply do not have time. Their demands on their jobs are much higher, and therefore they would not automatically be available or readily be available to firstly go for training. And even if they do go for training, a whole lot of them, even if you appoint them, I promise you, you are just simply not going to get the person to give you time. They've got a whole lot of things, service delivery imperatives would take precedence. Now, the collective agreement 7.6.1 is clear. When you appoint a presiding officer, the person must be at least 2 levels above the person that you are intending to charge, the accused employee. So you need then to zoom into this particular matter. If you were to appoint a person internally, you would have to appoint an HOD, because the brigadier level, and you will see in the suspension letter, it states that it's a C17. The C17, in terms of our job evaluation processes in the municipality, was the highest level that was evaluated for your bargaining unit employees, for your permanent staff establishment.
I'm sorry to interrupt you, Mr. Nciza. Ms. Muhlasedi, do we want to discuss the terms of this agreement as generally as we are now, or do we want to zoom in on what was relevant to the case of Brigadier Mkhwanazi?
Thank you, Chair. Yes, our aim is to discuss the two of the documents in the context of what was relevant here in 2 respects. Firstly, the constitution, or rather the appointment of an external chairperson and an external prosecutor, which will become relevant during the course of Mr. Nciza's evidence. The second important issue is who exercised or who bore the power to determine whether to constitute a disciplinary tribunal, and the documents are relevant for that assessment. I will endeavor to be very brief. I'll pose direct questions to
yes,
them.
I'm asking, for example, because as I understand the evidence here, people external had to be appointed. And I think that focus on the appointment of external people and why it had to be external people should be enough, without us getting into the situation where internal people would be used and why. Did you see what I mean?
I follow. Thank you, Chairperson.
Yes, thank you.
We'll
Thank
direct the exchange in that manner.
Thank you.
Thank you. Mr. Nciza, then my final question with respect to the collective agreement would be in respect of clause 7.6.3. You've indicated then that as a general rule, when constituting a disciplinary tribunal, the effort would be to obtain an internal candidate to act as a chairperson or as a prosecutor. Is that correct?
Yes.
Indeed. And then where that is not available, where an internal candidate is not available or not possible, there are certain circumstances where you would obtain a chairperson or a prosecutor who is an external person.
Yes.
Correct. And in paragraph 7.6.3, 7.6.3 reads that where there is a lack of suitably qualified persons or where the presiding officer is threatened or intimidated, the municipal manager or his authorized representative may appoint a suitably qualified external person. Is
Yes,
that
ma'am.
correct? Thank you.
Yes, ma'am.
And is it then fair to say that that exception or that alternative applies to the appointment of a chairperson as well as to the appointment of a prosecutor in a disciplinary tribunal?
Yes, it does. It's just that with regards to the appointment of a prosecutor, the collective agreement provides for additional considerations.
And what would those be, briefly?
Whereas the collective agreement does not speak to the presiding officer in respect of legal practitioners, it speaks to legal practitioners in respect of a prosecutor. And the fact that if you are to appoint a legal practitioner, then there should be an agreement between the parties, or alternatively, you should then apply to the presiding officer for the legal practitioner to represent the municipality.
Thank you. But, and just to confirm then, that even with respect to a prosecutor, where a suitably qualified person is not available, or there is an issue, a concern around a threat or intimidation, an external prosecutor may be appointed?
Yes.
Thank you. Mr. Nciza, I would then ask you to have regard to the document numbered as 15A.
Which one is that?
It's the document with the subject Directive for Implementation of the New Disciplinary Procedure Collective Agreement.
I have the document, but it's not numbered.
My apologies. You can just number that 15A. It shouldn't be, it's all right. We'll handle it for you over the tea break. It's all right.
I'm on it.
Thank you. And just to confirm, that document is a memorandum issued to all HODs and employees, and it cites their two unions. Do you confirm that?
Yes.
Indeed. Do you please confirm where the document originates from?
It originated from the HOD HR, Head of Department HR.
Thank you. And the emblem on the top right of the document reflects that it applies to which particular entity, please?
City of Ekurhuleni.
Thank you. And the date is?
The date is the 15th of February, 2018.
Thank you. Which is subsequent to the circular you've just taken the commission through?
Yes, ma'am.
Thank you. Could you just explain briefly what the purpose of this document is and how it is to be considered in light of the circular we've just discussed?
This document talks to the internal arrangements that I had spoken to earlier on, in terms of how we as the City of Ekurhuleni implement the disciplinary procedure that is contained in Clause 7 and other clauses of the collective agreement.
Thank you. Mr. Nciza, could I ask you to turn to paragraph 5 of that document, please? Paragraph 5.
Yes, I'm there.
Paragraph 5 is entitled, "The following principles shall underpin the implementation of this DPCA."
Yes, ma'am.
Paragraph 5.1 reads, "An allegation of misconduct against an employee shall be brought in writing to the city manager or his authorized representative." Is that right?
Yes, ma'am.
And the authorized representative in this case applies to who? You indicated that it might change in certain contexts, but here, within the context of an allegation of misconduct,
Would be the HOD, Head of Department.
And based on our current facts under discussion today, that would be, for example, Chief Mapiyeye.
Chief Mapiyeye, yes.
Thank you.
Continue. Ms.
Thank you.
Mutshekga.
Thank you, Chairperson. Paragraph 5.2 then reads, "A supervisor or another employee investigates the allegation of misconduct and submits the investigation report with a recommendation to the relevant HOD."
Yes, ma'am.
In the context of the facts under discussion today, who would be the supervisor or employee tasked with the investigation of misconduct here?
Under these circumstances, the employee would be Lieutenant Colonel Erasmus.
Thank you. Who you confirmed earlier is from the Integrity and Standards Division. Thank you.
Yes, ma'am.
Paragraph 5.3 then sets out the next step, and it says, upon receipt of the investigation report, the relevant HOD, who I now understand to be Chief Mapiyeye, shall complete and submit the disciplinary initiation request form to the DH Employee Relations for the initiation of the disciplinary proceedings. Is that right?
Yes, ma'am.
Thank you. So in terms of this paragraph, Chief Mapiyeye should then, it contemplates that Chief Mapiyeye shall then complete and submit the disciplinary initiation request form to the DHER, who is?
Myself.
Thank you.
And critically, it says initiation request.
Indeed.
Yes.
Indeed. And then for completion on this note, paragraph 5.4 says the office of the divisional head ER shall identify and appoint a presiding officer and employer representative. Is that right?
Yes, ma'am.
Thank you. So, Mr. Nciza, these documents then read together set out a procedure for the institution of the constitution of a disciplinary tribunal. Is that correct?
Yes, ma'am.
With the idea that an allegation is presented to an HOD, who then appoints someone to investigate the allegations and submit a report, and that report is then accompanied by a request to yourself for the initiation of disciplinary proceedings. Is that a fair reflection of the content of the documents?
Spot on.
Yeah. On that note, could I then ask you to have regard to your witness statement again, where we are now on paragraph 38. Paragraph 38, please.
Yes, I'm there. Page 14.
And at paragraph 38, you say there, on the same day, I signed the approval of the recommendation to constitute the tribunal within 3 months. Is that correct?
Yes, ma'am.
Thank you. You make reference there to an annexure PN6. On page 288 of the annexure bundle. PN6.
I'm there.
Thank you. Page 288 of the annexure bundle. I'll just ask you to put your finger there so that we can place the full document on record. If you flip one page back to the front of the document.
On page
287.
287.
Yes, please. 287, one page back,
Yeah.
is the first page of the document, and it is titled Request for Disciplinary Tribunal. Is that correct?
Yes, ma'am.
Thank you. At the top of the page, it is directed to yourself. Is that correct?
Yes, ma'am.
It originates from the Chief of Police, Mr. Isaac Mapiyeye. Is that so?
Yes, ma'am.
Who you've identified as the HOD referenced in the documents we've discussed?
Yes.
Thank you. The document then sets out that an accusation of misconduct is brought in terms of the disciplinary procedure against Mr. J.D. Mkhwanazi as the employee. Is that correct?
Yes.
Thank you. Importantly, Mr. Nciza, the document continues to identify the nature of the alleged misconduct, but I would ask you to return to page 288, to flip over to page 288.
Yes, ma'am.
Thank you. Under recommendation at the top of the page,
Yes.
the document provides for two options. The first option, one, is a request or permission to hold a departmental inquiry. And option 2 is a request for the establishment of a disciplinary tribunal. Do you see that?
Yes, ma'am.
Thank you. And at the bottom is a straight line that makes provision for a signature. Could you identify the signatory there, please?
The signature there is one of Chief Mapiyeye.
Thank you. And just above, as contained in that box, what is the recommendation that Chief of Police Mapiyeye made or sought and directed towards you?
Chief Mapiyeye had ticked the second box, which is for a request for the establishment of a disciplinary tribunal.
Thank you. At the foot of the page, you will see then a signature. Could you identify the signature? Who signed there, the signatory?
The signature at the bottom of the page is mine.
And could you identify the content of the boxes just above the signature?
There are 3 boxes above the signature. There is further investigation, departmental inquiry, and disciplinary tribunal.
Thank you. And which of the boxes did you tick in indication of an approval?
Disciplinary tribunal.
Thank you. For completion, Mr. Nciza, yesterday you engaged with Commissioner Baloy about the options available to the head of employee relations once they receive an investigation report, a so-called docket. And you indicated that there are 3 of those options.
Yes, ma'am.
Having gone through the contents of the collective agreement, you've explained that a departmental inquiry is suitable in instances where the allegations of misconduct are of a less serious nature. Is that right?
Yes, ma'am.
Whereas a disciplinary tribunal is most suitable where an employee is facing particularly serious allegations of misconduct.
Yes, ma'am.
Did that distinction then affect the decision that you ultimately took when considering this request from the Chief of Police?
That distinction always affects the decision that one makes, because you have to weigh the evidence and the merits of the case as presented in the investigation report before you go and tick the box.
And in considering the weighing up of the evidence that was provided to you, you annex at paragraph 37 of your statement, you annex the investigation report that was provided to you. Do you see that? Paragraph 37 of your statement on page 13, right?
Yes, ma'am.
Thank you. If I ask you to flip over the page, you've then informed the Commission that upon receipt of that report, you considered its contents and then you signed the approval to constitute a tribunal.
Yes, ma'am.
Indeed. And in the paragraph immediately thereafter, you set out briefly the justifications for why you were minded to sign the recommendation to constitute the disciplinary tribunal.
Yes, ma'am.
Thank you. Now, Mr. Nciza, the Commission has, over the course of the past few days, heard extensive evidence from Commissioner Spies as well as Chief of Police Mapiyeye about their view as to why the allegations as they related to Brigadier Mkhwanazi were warranted and therefore justified the taking of disciplinary steps. But you also set out in your own view what motivated your decision to constitute that disciplinary tribunal. Could I ask you then to turn to paragraph 39.1, paragraph 39.1 of your witness statement? Are you there?
Yes, I'm there.
Thank you. If I can assist you, please turn to page 36 of your annexure bundle, page 36.
36.
Yes, please.
I'm there.
Thank you. So, to locate this discussion in the context of your annexure bundle, you've annexed annexure PN5, which is the investigation report.
Yes, ma'am.
Thank you. You've confirmed that that is the report that was provided to you on
Yes,
the
it
12th
is.
of April. Thank you. And that it is the report that was provided, or rather prepared by Colonel Erasmus. Is that correct?
Yes, it is.
Thank you. You don't need to go there, but on page 21 of the annexure bundle, it sets out a list of documents that are relied upon in the compilation of the investigation report.
Okay.
Okay.
Yeah.
So if at any stage you require assistance in navigating those documents, I'll assist you.
Okay.
Great. I'll also note for you, Mr. Nciza, that the docket or the investigation report provided to you is some 250 pages, so it's a comprehensive document. But you've done the task of isolating several documents that you wish to talk through today. Is that right?
Yes, ma'am.
Right. So with that overview provided, could you then go to page 36 of your annexure bundle, page 36?
Yes, ma'am.
Isn't there, Ms. Mutlasedi, a more legible copy of this?
I apologize, Chairperson, that's the
That's the
quality
best
as
we
provided
can-
to us.
yes.
Yes, indeed.
Is the one on page 54 the same as the one on 36? 54 seems to be much better. Not by
Thank-
much, but slightly.
Thank you, Commissioner. It's larger. That is much better. Thank you. Mr. Nciza, you've been graciously assisted by Commissioner Kumalo. Please turn to page 54 of the annexure bundle, page 54.
Oh, yeah. Got it.
Thank you. Right. Now, in paragraph 39.1 of your witness statement,
Yes.
yes, you set out briefly there one of the considerations that motivated you to constitute a disciplinary tribunal. Could you please take the commission through that?
Thank you, Counsel. Commissioners, my reflection on this letter was what jumped out, first and foremost, is the usage of two titles. You know, at the bottom of page 54, you find that there is J.D. Mkhwanazi with a signature, and then it's acting deputy municipal police commissioner / brigadier. Now, I've been in HR management for more than 20 years. That does not happen. When you're acting in a position, you perform both functions, you know, of the substantive post and the acting position. So if you're going to write a letter in your capacity as Brigadier Mkhwanazi, you write the letter and you sign it as Brigadier Mkhwanazi. Because the delegations, the authority that are in the position of Brigadier are clearly defined. And you can exercise authority up to a particular point as Brigadier. But then when you are acting in your superior's position, you then assume the delegated authority that resides in that position. So if you're going to write a letter, you must distinguish who is writing the letter. Is it the brigadier who's writing the letter? Or is it the acting commissioner who's writing the letter? Because then if tomorrow there is there's litigation about the letter.
Mr. Nciza, but he still was a brigadier, was he not?
He was a brigadier.
Aren't you reading too much then into this? Was he not merely indicating his rank, that he is a brigadier?
With all due respect, Commissioner, it doesn't work like that. It doesn't work like that, you know, because, like I say, different positions carry different authority. So if I am the manager, collective bargaining, and I'm acting as DH, employee relations, if I write a letter that is within the scope of my function, my substantive position as manager, collective bargaining, I will indicate that this, because it talks to my substantive position. But if I'm writing a letter that speaks to the acting position that I'm busy with, that I'm acting in, then I must indicate that. The acting policy of the municipality states very clearly that when you are acting, you perform both roles. You must perform the role of the manager as well as the commissioner.
But would you completely discount the possibility that he could merely have been indicating his rank and nothing more? Would you completely discount that possibility?
I wouldn't completely discount the possibility. It's just that the content of the letter then brings me to this, to say that in my view, this was intended to obfuscate the roles. You know, it was creating this, because at the end of the day, if for instance, I'm to deal with the actions of the employee, and if I'm to say, but you acted outside of your scope, you know, I need to understand exactly in which scope were you acting. Were you acting as the brigadier or were you acting as a commissioner?
All right, I'll leave it there.
Would you have had the same concern if he had signed, as he did there, if he had said Brigadier J.D. Mkhwanazi, if that's the first line, because he just says J.D. Mkhwanazi. If he had said Brigadier J.D. Mkhwanazi, and then in the next line say acting police chief, the way that he has done, would you still have the same concern that you're raising?
Which lines are those?
So that same signature area the chair is discussing with you. So he's got just J.D. Mkhwanazi. You see where I'm referring?
Yes.
Okay. I don't know how people sign in the municipality, so my question comes with that, Ryder. If he had said it at the bottom there, if he had said Brigadier J.D. Mkhwanazi, so he describes himself, the title and name, Brigadier J.D. Mkhwanazi, and then in the next line, he then says acting deputy police something.
Okay.
Sorry, I can't see a thing at all here. Would that still have raised the same concerns that you're raising?
It would have, but perhaps it would have been a bit different in the sense that, remember, and I think the previous witnesses testified on this, you have the rank of brigadier, you know, and then you've got a post designation in terms of your organizational structures. You know, now if he had said Brigadier Mkhwanazi and then said underneath, he'd called himself Brigadier Mkhwanazi, and then underneath indicated that is acting deputy chief of police. Again, it still creates the challenge from an HR point of view to say exactly who is signed, but it could easily be dealt with by what we are raising. Say that, okay, fine, it's Brigadier Mkhwanazi, but it's acting. So the person who is actually signed is the acting, as opposed to both, you know.
I would understand your point if he had signed as both acting deputy municipal police chief and director of specialized services. But here it's clear that he's referring to only one role, and the brigadier is the rank he holds, and that is the chairperson's point, that it is the rank, whereas the role is that of acting deputy municipal police commissioner. Now, if he had said acting deputy municipal police commissioner / director of specialized services, then that would be different because those are two different roles. But his rank does not change whether he's acting in one role or the other. He remains brigadier.
I get the point.
That's really the chair's point.
I get the point. If you put it that way, I get the point that you're raising. Yeah, thank you, Commissioner.
So I failed in putting across my point.
I get the point. Thank you, Commissioner. So that is the issue that jumped out, but nonetheless, the contents of the letter themselves, you know, the author of the letter says that there is a memorandum of understanding that is signed with CAT VIP. Now, there is no memorandum of understanding that existed between the municipality and CAT VIP. You know, when I looked at the docket, there is no signed memorandum. There is no memorandum that has been entered into. So this is grossly dishonest in my view, to say that there is a memorandum when such does not exist. The fact that there is a draft is that it's just simply that it's a draft. There is no actual memorandum that existed. But this letter, makes a representation that there is a memorandum of understanding between this company and the municipality when such does not exist.
Thank you, Mr. Nciza. You then make a concluding remark at the end of paragraph 39.1, where you say that this representation or this was intended to clothe this arrangement with some form of regulatory standing where there was none. Is that correct?
Yes.
Thank you.
And that is basically because he did not have the authority to issue such a letter in any event.
Thank you.
So something else in that first paragraph, it may not be significant. He says, the letter serves to confirm that the EMPD, and this is the part that I just want you to confirm the correctness of, under the command of Acting Deputy Municipal Police Commissioner. So as Acting Deputy Municipal Police Commissioner, did the EMPD fall under his command?
No. The EMPD falls under the command of the Chief of Police.
So
even if he was not acting.
Yes.
Even if he was not acting. Remember, structurally, the EMPD had various divisions. So the Deputy Municipal Police Commissioner is the head of a division. He's not the head of the department. He's the head of the division. I can't say, as the divisional head employee relations, human resources is under my command. It's not. I'm just the head of a unit. So it was incorrect for him to say that EMPD under his command.
So it was a misrepresentation.
It was a misrepresentation. That is the first misrepresentation, right at just off the blocks. But then another misrepresentation is made. The misrepresentation about an endless working relationship. Firstly, there is no working relationship, let alone an endless one. He had his working relationship, not the municipality, not the EMPD. What became clear in terms of the investigation is that indeed there was some working relationship, but it's not a working relationship of the municipality with CAT VIP. It is not the working relationship of EMPD with CAT VIP. It is a working relationship that he has constructed, outside of regulatory framework, outside of the policies of the municipality, outside of legislation. He constructed that relationship. And hence, perhaps he terms it as an endless working relationship because he has every intention of not separating from CAT VIP. Whereas the municipality enters into all forms of relationships, but they are defined. They are defined. There's a process to enter into a relationship, and there is a period of a relationship.
Thank you, Commissioner. Mr. Nciza.
Please remind me, Mr. Nciza, for whose consumption again was this intended? I see there's no specific addressee. It says to whom it may concern.
That is another a worrying factor, Mr. Commissioner, Mr. Chair, because when you address an official letter, you address a letter to a specific individual or entity. This is addressed to whom it may concern. So the bearer of this letter can then claim that I am the whom it may concern. And therefore, note that I have this relationship with this state entity, and my actions are covered under this letter. It's just too wide, and it has potential to create serious problems. We don't know, even up to today, who actually then had this letter and what did they do with it. No, I have not come across any information that says the people that got this letter, if it was CAT VIP people, what did they do with this letter? And that's a scary thought that a letter of the municipality can be in the hands of individuals, so that even if they get into a roadblock, even if they get into all sorts of other situations, they will not be checked. They'll just simply say, but we are in a relationship with the MPD. You can't touch us.
And it is, when you say they, it is these vehicles. So this
Yes.
letter lists vehicles.
Yes.
So if any one of these vehicles got into a situation such as you're describing, they would show this and say, I am that vehicle.
I'm this vehicle,
here
and therefore,
working for the municipality.
I'm clothed with this, what you call protection, if you want to call it, but effectively, because I've got this relationship and therefore I work with the MPD and I do these things with the MPD, so who are you therefore to obstruct me? It would be as if you're obstructing police.
Let us adjourn and resume at 11:15.